Chairman. Thank you for calling up the bill today, the Co-op Consumer Protection Act. This is a short, simple bill with a basic premise. If you are a consumer who complied with the ACA's individual mandate by purchasing health insurance through one of the consumer-oriented and operated plans, or co-ops, created under the law, and your plan was terminated mid-year by the failure of that co-op, you shouldn't be liable for the individual mandate for the remainder of that calendar year. We've already had a hearing on what happened with the co-ops, so I won't spend a lot of time rehashing that history. In short, $2.1 billion, largely in the form of startup insolvency loans, was distributed to approved co-ops. Now, 16 of the 23 co-ops, which received $1.7 billion of those dollars, have closed or are in the process of closing, with the remaining 7 also struggling to remain solvent. The first of these co-ops to close was Co-Opportunity Health, which provided plans covering 120,000 Nebraskans and Iowans in 2014, before being taken over by the Iowa Department of Insurance late that year. Co-Opportunity plans were wound down in the first quarter of 2015, and consumers were given an opportunity to select a new plan through the exchanges. While health providers in Nebraska and Iowa were made whole for services provided to Co-Opportunity plan holders through the state's guarantee funds, consumers and the remaining insurers in the 2 states are now paying back the guarantee funds for those costs. Similar situations have played out in other states covered by collapsed co-ops, including states like New York and Illinois, where plan holders have lost coverage mid-year. When Co-Opportunity collapsed, I heard from nearly 300 constituents with concerns about what this change meant for them, including concerns about penalties for lapses in coverage, about having to cover deductibles twice in the same year, and about seniors very close to Medicare who were healthy and simply didn't see the point in dealing with a brand new insurer for a short time before transitioning to Medicare. I've previously shared the story of Pam Weldon, a constituent from Minutair in my district. She approached me because she had lost coverage 3 times in a little over a year. First, the plan she had prior to the ACA, which covered her pre-existing condition, was canceled. In its place, she chose a plan from Co-Opportunity Health, which Co-Opportunity phased out after 1 year in an effort to remain solvent, and finally a second Co-Opportunity plan was terminated when the co-op was wound down entirely. Another constituent, Melissa Lordeman of Hardington, wrote to me the day after Christmas in 2014, concerned that their Co-Opportunity plan was ending in early 2015, and that her family, including her child with medical needs, would find themselves paying a deductible twice or paying the individual mandate penalty for part of 2015, neither of which they could afford. While both these situations were worked out with minimal disruption, it is only fair that we reduce the impact further for these families and ensure that if any other co-ops close, that families struggling to make an unexpected decision about health insurance mid-year don't have individual mandate penalties to worry about as well. I know there are diverse views about the individual mandate on both sides of the aisle. The bill isn't about that. It is about ensuring consumers aren't caught in the crossfire, and I ask for your support. Thank you. I yield back.
Thank you. At this time, I recognize